Hello, Brian, would you like to introduce me or shall I just jump in?
Just go ahead and start.
Okay, welcome everybody. I'm here, my name is Helen Sedgwick. I'm a California attorney, but I've been doing this for 30 some years, helping entrepreneurs and small businesses with legal issues. And today I'm going to do a user-friendly presentation about the 5 legal issues every writer should know. This is whether you're publishing traditionally or you're an indie publisher and doing your own books and other books. There are some basics because you are now in the business of selling your rights and selling intellectual property. So there's some terminology and some concepts that you need to get a handle on. This is your stock and trade. But I can assure you that these issues are easier than writing a book. Writing a book is much more challenging. So I'm going to make these very user-friendly, very nuts and bolts what to do to help you take on these matters. So again, a little bit about me. I am an attorney, but I've been a closet writer for decades. In 2013, I self-published a novel known as Coyote Wins. And when I self-published that, I realized that especially indie authors were facing a lot of issues, legal issues, and that befuddled them and intimidated them. So I wrote the Self-Publisher's Legal Handbook that covers a lot of what I'll be talking about today in more detail, and also covers issues such as pen names and collaborations. So let's today start talking about those 5 issues. The first one, these are basically, what do you own? How do you protect your work? When do you ask for permission to use work created by others? How to spot scams and myths, because there are many companies out there promoting these to writers. And then finally, why you should treat your writing as a business. So let's look at what you own. When you create an original work, now original does not mean that it has to be earth-shatteringly new and different. It just means that you didn't copy it from something else, and it's more than just a phone book. It has some expressive content. As soon as you put a creation in tangible form on a piece of paper, on a hard drive, you're uploaded on a site where it's been recorded, you own the copyright in that work. It's automatic. It used to be that that copyright didn't attach unless you registered the work or you put the C circle on it and put the notice on correctly. That changed about 30 years ago, and now copyright attaches automatically. And it lasts for a very long time. It will last for your lifetime plus 70 years. In some countries, it's 50 years, but it's still quite likely that your grandchildren and your great-grandchildren will still have a copyright in your work. Now, as I said before, publication, notice, and registration are no longer required. However, I still recommend that people put the copyright notice on their work, which is typically the C with a circle or the word copyright, the year or years in which the work was created or published, and then your name. Could also be your pen name. It could also be your imprint name. That puts the world on notice that you are claiming the copyright to this work. It also makes it easier for people to find you should your work, let's say, be posted online. And then registration is no longer required. This is registration with the U.S. Copyright Office, but it's also something I recommend. If you register your copyright, which is easy to do online, you just go to the U.S. Copyright Office, then you have additional rights should anybody infringe upon your copyright. And if you register that work within 3 months of its publication, you can recover attorney's fees and something called statutory damages, which is basically you would automatically recover money from an infringer without having to prove actual lost sales. But even if you miss that 3-month period, it makes sense to register your copyright. It costs $35, takes about 15 or 20 minutes. It's easy and there are no excuses. There are some attorneys out there, and there are websites and YouTube videos that actually will show you, walk through the process of registering a copyright on the U.S. Copyright Office. But it's not a difficult process. It's really basically going through a menu of steps. And you can register with the U.S. Copyright Office even if you're not a U.S. citizen. You would have to do that if you were going to sue anybody for infringement in the United States. But what it also can do is it creates a public record of what your work looks like on a particular day. And should you ever have to prove ownership or infringement or anything like this, having this proof of ownership would be extremely handy. So let's take a look at what's protected by copyright. Text like manuscripts, poems, lyrics, scripts, news articles, your blog posts and web pages, images like photographs, sketches, paintings, movies, recorded dramas, songs, musical notations, and architectural work. Again, all this is a creative, expressive work that's been fixed into a tangible medium. But what is confusing to people is what's not protected by copyright. Your ideas and your concepts, basically the idea of a romance between creatures of different planets in the distant past, that basic concept, even if there's some clever little twists in it, you don't own it, nobody else owns it. It doesn't mean they can't stop you from writing about it, and you can't stop someone else from writing about it. Facts, names, and events are also not copyrightable or protected by copyright. If there's an historic event, an historical figure, you can use those historical events and figures in your stories. John Steinbeck doesn't own the right to tell the story about the Dust Bowl, even though he wrote The Grapes of Wrath. Even if one person has discovered an obscure historical fact, they don't own that piece of information. Information can be used by you to create a whole new story or dramatize the past. Other things that are not protected are stock characters like the tough-talking gangster or the sweet but dumb hero. Same with storylines. The Romeo and Juliet storyline has been told many, many times. Book titles and song titles are not protected by copyright. So, and this is very handy because a lot of times people want to reference a song in their novel. I mean, using lyrics is a very quick way to help pull the reader into a particular setting or to show your character's preferences. Using lyrics, I'll talk about shortly. Lyrics are protected by copyright, but the song titles are not. Book titles can sometimes be protected by what's called trademark. If you have a series of books that's become very recognizable by a certain name, such as the For Dummies series, you can get a trademark, which is a different beast, I'll explain in a moment, for the concept of a For Dummies series. But for a single book, you won't get a trademark. You'll be able to register a trademark in most cases. The exception would be if it's an extremely successful book, you might be able to claim that nobody else could use your title. This is one reason why you'll see if you go on Amazon and you search books with the title Betrayed, you'll see probably 25 books with that title or Betrayed by something, and everybody can have the same title at the same time because they're not copyrightable. And lastly, there's things, short phrases under 15 words. Some people say 30 words. those generally are not protected by copyright. I mean, the internet is full of people doing graphics with these short videos, these short quotes. The exception would be lyrics. You have to be very careful about using lyrics. And I'll explain how to get permission to use lyrics or when to get permission. And it's not that lyrics are special in the eyes of the law. It's because lyrics are usually owned by music companies, not by the artists. And the music companies can be very aggressive about enforcement. Now, some people say, how are they ever going to know it's in my book? If your book is successful, they might know and they might care. So when you own a copyright, that means, the biggest thing it means is you control the right to publish and reuse that work and market it to the world. And so that can be a very valuable right. And you may not know when you're writing it, when you dream when you're writing it, that it's going to be worth $1 million and they're going to make movies out of it, but you don't know. So you want to protect that work. And so you think, a lot of writers are worried that if they show it to agents or publishers, they're going to steal the idea. Or if they write about a family secret, they're going to get sued for defamation. Or if they put, that they worry about these sites that offer free downloads of books. All those are risks. But in my experience, the biggest risk that writers face is when they sign bad contracts. And I'm going to tell you something about what to look at in contracts. Every year, there are going to be a few hundred writers that may get sued for defamation, but there are going to be tens of thousands of writers who signed onto contracts that they come to regret. So not everybody has a lawyer in the family they can call and help on this. So you need to kind of know what issues to look for and how to spot where there might be an issue. So I'm going to start with a little vocabulary here. First, when you work with somebody to publish your book, whether it's you're self-publishing and working with vendors, or you're working with a traditional publisher, or something in between, like a hybrid publisher, what you're giving them is you're not really selling your book. You're giving them a license to publish and exploit your work, is how they use the phrase they use. And it's a permission to use. It's not a transfer of ownership. Anytime you see a contract that uses the word assign, like you are signing all your rights or you're assigning your copyright, you should not sign that contract unless you really know what you're doing. Like if you're working as a ghostwriter or you're working for a magazine, because once you've assigned something, you're actually transferring ownership. In 99% of the cases, what you're going to see is what's called a license, which is permission to use. That license might be exclusive. If you're working with a traditional publisher who's going to be doing the investing in editorial and design and marketing, they're going to want exclusive rights to your book in exchange for their investment. In contrast, if you are self-publishing, which means you are doing the investment in editorial and design and marketing, then you're working with CreateSpace, Ingram Spark, a local printer, you're doing offset, you're going to be, or ebooks you're doing with Smashwords and other providers, you're going to give them what's called non-exclusive rights, meaning that you can use Smashwords and you can use Kindle. You can distribute it through Kindle and Amazon at the same time. So nobody has exclusive rights. The other terminology is reversion, which is when do the rights, this permission to license, when do those rights come back to you, under what conditions? And then finally, the last term to remember is what's called subsidiary rights. It's a bucket of rights that could include movies, plays, TV, translations, merchandise, etc. So you have all these words in your head and you're thinking, how am I going to read a contract? I mean, contracts for most people, look like 5,000 words run through a blender. So I'm going to give you a couple hints on what to do when you get a contract. The first thing you do is you do not start at the beginning. If you start at the beginning of the contract, by the time you get to the places that you really need to be careful of, you're worn out. So when you get a contract, and I do this, you start with the key sections, which may be buried in the contract, but they usually are titled grant of rights or license or ownership, something along those lines. I'll show you some samples in a moment. Your goal is to keep those licenses, those permissions to use, as narrow as possible. When you own a piece of work, think of it as like you own an office building. And one space might be print rights in English, another space might be ebooks in Spanish, another space might be audiobooks in Chinese. What you want to do is work with providers or publishers who can do the best for you in their little space, in their category. What you really don't want to do is give somebody rights, a small publisher who really is only printing and distributing and publishing English print books in the US and Canada. You don't want to give them rights to do audiobooks in Mandarin and ebooks in Spanish. They can't help you in that category, but you will get a contract that will show as if they're taking the whole apartment building, the whole office building, even though they can't use it. And so what that lacks is synergy. You have to look for synergy with your providers, particularly a publisher, something that everybody benefits. And you want to determine whether they're really capable of expanding your reach and of paying you. What I often see is writers, especially as they're starting out, sign on with a small publisher. And the small publisher, they're honest, they have the best intentions, they're trying to do a good job, but they're new to the business, they don't really know what they're doing, they get overextended, they can't pay, they're disorganized. And so it's not a question of them trying to being fraudulent, they're just kind of incapable, which can be just as frustrating and damaging to a writer. I don't think writers should ever sign on to just rights of first refusal and options, except with a substantial publisher who actually has the wherewithal to, has a synergy to actually take these further books and do something with them. Again, with a small publisher, they may have this right of first refusal on your future work, even though they barely got your first work out and barely get any books out, and that's going to get in the way of you working with other publishers. You should always look at how to terminate a contract. I mean, not every business relationship works out. Some of these things might be if the publisher doesn't get your book out within a year or 2 years, something negotiated. It could be if sales drop off to a certain point. It could be, of course, if they go bankrupt, you want to be able to get back your rights. And don't feel that you have to go it alone. There are, in a lot of states, in California and Texas and Ohio, there are often lawyers for the arts organizations that have usually teams of lawyers who are willing to help artists of various sorts for no fee or a very reduced fee. The agent will help you, your local writers or independent publishers organization might help you, but don't assume that you have to go this alone. So when you're dealing with contracts, and you will be dealing with contracts, this is how you're going to get your work out there. In any negotiation, preparation is the most important thing. It means if you get a contract, you need to study up on what's negotiable and what's not negotiable. And there's lots of advice on the internet. You need to understand what you want and be able to say why. I negotiate big contracts for all kinds of businesses. And in 95% of the cases, everyone wants to be seen as a reasonable person. So if you say, no, I can't give you the rights to do my books in Spanish because it could be a huge market, or I want to change the story slightly, or I don't think you can take advantage of those rights and make me any money in that market. You'll be surprised that in almost every case, if you present a reason why you don't want to agree to a particular contract term, the other side will either agree with you or they'll come back with something in between. It always helps in a negotiation to try to understand what the other side wants and what they're going to ask for and why. It's just going to help you find a solution that works best for both parties. And a business contract where both parties have something to gain is much more likely to be successful. And then just keep going back to asking yourself whether there's synergy. I had touched on earlier a couple other risks that I kind of dismissed, but I might as well go back to them for a moment. Online privacy, if your book is published, whether it's traditionally published or self-published, and you search your title online, you are going to see people offering free downloads. You can chase them down with something called a takedown notice, and if you search takedown notice, you'll find services that will help you with that. But the common wisdom is these sites that are offering free downloads are actually not offering free downloads of your book. They're probably offering the free portion of your book that they can get off Smashwords or Amazon, and then they are downloading malware onto people's sites. And I just say I don't bother chasing these sites anymore. I did it first, but it's like playing whack-a-mole. You could be doing it forever. I just say to myself that anybody who's downloading my book, the legal handbook, from these sites probably wasn't going to pay money for it anyway. It's very rare that agents or publishers steal work, or you hear that alleged. You do hear that in the movie business, but not in the book business so much. Agents and publishers are in the business of working with writers and taking work and developing it and improving it. If they were to get a reputation or be hit with a rumor that they stole someone's work, they could be run out of business because no one would work with them again. So generally, their reputation is more valuable to them than your work. And a whole other topic, which I've talked about online, is about defamation. Again, it's really a low risk, particularly for a writer in the United States. Defamation is a very difficult case for a plaintiff to prove, and it usually calls more attention to a matter they would rather have forgotten. And often when writers get sued for defamation, particularly if it's by a public figure, their book sales take off. So if you're doing kind of a high-risk book and you're working with a traditional publisher, they will sit and talk with you and their attorneys about the risk. And the business people may say, what the heck, let's just go for it. If we get sued, we'll make even more money. It's a high-stress situation, but it does happen. So going on, now let's look at some sample contracts. One area where there's some real risk to writers is in the contest area. There are contests out there that offer a publishing contract. That might be fine, but really what you're doing in a lot of these contests is offering a publisher a chance to look at your work, often on an exclusive basis, and to publish your work, and you have to sign their contract and you don't get any advance. For instance, this is an example of a contract for a contest, and this was a publisher of a children's book app. Very small company, and I think has since gone out of business. However, this is what, if you submit your manuscript to this company, you would be giving them exclusive, worldwide, perpetual rights with the right to sublicense your work in book, print, audio, sound, in all languages, in all formats, even those that don't yet exist. The contract also goes on to say they have the right to create a series or other derivative books and merchandise based on your storyline, characters, illustrations, and that you don't have the right to say no. They do have to pay you royalties, but this is a company that provides no synergy in merchandise or other areas. This is not like you're working with Disney that's going to get your merchandise in every store. So this is an example, and you'll see this a lot, of an overreaching contract when you see words like exclusive, worldwide, perpetual, all these different formats and future formats. And this is an example of a more appropriate license. This is for a traditional publisher, and this may be more narrow than you can get, but it's certainly worth asking for, where you grant the publisher the sole and exclusive right to publish the work in print and digital formats in English in the US, territories, Canada, during the term of this agreement. And the term, again, we talk about how it expires. So this is a lovely limited license. Many writers are afraid to ask for this. They feel it's almost like this publisher's come to you, you don't want to rock the boat, you don't want to cause trouble or be seen as a troublemaker, so they're afraid to ask to limit the license to what's appropriate in this context. And I just urge you, don't think that way. This publisher would not be coming to you if it didn't think that it could make money from your book, or hoped and dreamed it make money. And if you come back and you're reasonable about your requests and you have your reasons why, they are more likely to have more respect for you and to realize that you're a business person and you see things in long-term, a long-term relationship, and you are somebody they want to be in business with. I'm going to transition now to another topic, which is when you're using the work of other creators, let's say a cute kitten photo, or quotes or material created by other writers, when do you need to ask permission? The important thing to remember is giving credit is not enough. If you just say that if you take a paragraph or 2 paragraphs or a page out of someone else's work, or you take a very important image and you give the person credit, that's fine, but it's not going to save you from an infringement claim. They own that work. They have a copyright, even if there isn't a copyright notice on it. As you recall, I said you don't have to do that. And if you're using their work in any kind of commercial manner, or even pretty much any manner, you are infringing on their work. So really be very careful and just don't pluck images and poems and songs off the web and stick them on your blog or stick them in your book. You really need to think about who might own this work and whether your use of it will require permission. Now, I mentioned earlier about lyrics. Remember that you can use the song or book titles without permission, and you can use the artist's name. There are alternatives. You can use work in the public domain. Generally, any work first published before 1923 is in the public domain because the copyright is expired. You can use work in which somebody has made available by putting a Creative Commons license mark on it, and I'll talk about that a little bit more in a moment. And what I do is when I want to use an image for my blog or the cover of my book, I go to stock image companies and I just buy an image. I mean, the downside is someone else could use that image as well, and you could end up with books, several books out there would have the same image. But if you're going to be, particularly if you're going to be using on a book title or your web page or something that's involved in marketing and promoting and getting attention for your work, it's better to have either a stock image or permission than to go bare. There is a concept of fair use, or in Europe they call it fair dealing. That is one exception from when you need permission. Fair use is basically using the work of others, often on a verbatim basis, for purposes of commentary, education, criticism, parody. There's a whole bunch of uses that are appropriate. As an example, if you were to use the lyrics, if you were to compare the lyrics of Bob Dylan and Eminem, to look at their treatment of women, and you just take their lyrics and you digest them and compare them, that would be considered fair use. But if you were to use the same lyrics in a scene to evoke a time and a place, that would not be fair use. If you think about it, what you're doing is you're kind of borrowing the creative spark of somebody else as a shortcut for your own writing, and that's where it's going to get you into trouble. Because this is such an area where I get questions so many times about what do I do about lyrics and what do I do about images, I actually have 2 free downloads on my website. These will go into a lot more detail about what is fair use, when do you need to get permission. I have sample letters to get permission. I give a lot of examples, particularly for lyrics, like how do you figure out who wrote the words. So it's much more than I could go through in a webinar, and it's the kind of information you wouldn't absorb without having something right there in front of you to refer to. So please go to my website, helensedwick.com, under resources, and you can download these for free. They also will go more into what a Creative Commons license is. So let's take a moment and talk about scams and myths. Sadly, I think writers and creative people are very susceptible to these sales pitches that you're inundated with. We live in dreams. We've worked very hard. We feel very passionate about our work. And we keep thinking that for $99 or $199 or $999, we'll join the club of bestsellers. In all fairness, not all of these offers are scams. Some of them are simply myths. I mean, they do deliver the blog tour or the tweet or the service, but the boost in sales just simply doesn't happen. So what are some of the things you need to be aware of as you're navigating this world of selling your work? One is these, quote, publishing companies that pretend to be selective. They ask you to submit their work, but they act like traditional publishers, but pretty soon they're asking you for your credit card, and at that point you should be aware that they are not a traditional publisher. They are a self-publishing company or a vanity press. So I don't think they're selective at all, except that they're trying to weed out the very worst or the most profane or obscene work, but they probably accept 99% of their submissions. I think their flattery is meant to loosen your wallet. You'll get book fair invitations that you could be at the Frankfurt Book Fair or some huge book fair for $1,500. You get 15 minutes. Your book has 15 minutes on their table. It's not worth the money. If you really want to go to one of these big book fairs, you're better off working with a team of other writers and getting your own table. Hollywood pitch experts. These are frightening. I worked with I worked with his son, or his father, who at 90 years old was talked into buying these Hollywood treatment and pitch programs, and it was like by the time the son got involved, he had paid $35,000 to one of these companies. And he basically, these were like 2,000 word, 3,000 word little pamphlet books. It was such a ripoff. So again, they're appealing to, they're wanting to be remembered and wanting to be acknowledged. They tend to really go after older memoir writers. One reason why a lot of these scam artists and myth artists go after the older people is that older people, when they realize they've been ripped off, often don't report it to their family or to their police because they're afraid the family will come in and take their autonomy away. I think there's a special place in hell for people who do this, but I'm digressing. Watch out for people who say they can get you on the hot list. Like, I've gotten pitches that I could be on the hot list for speaking engagements at schools for my novel, which is a young adult novel. And to get on this list would cost $3,500. I would never be able to make that money back speaking at schools. Most schools, you don't get paid. In fact, they hope that you donate some of your books to the library. Same with media packages, people who contact you and they say they want to interview you for a radio broadcast. And it's fine, but the radio broadcast or the web broadcast will only appear if you pay them $3,500. It seems to be a favorite number. Some contests, and I'll give you some guidelines on contests in a moment, but some contests have no prestige. They're merely money makers. There are some fake self-help sites, and this is across all kinds of industries. These are sites that say, let us help you find the right self-publishing company for you. And they go through a list of questions about what you want to achieve and what your visions are. And then they always go to their own companies. Author Solutions has several of these sites out there. They pretend to be there to help you, but they're always going to point you to one of their sites. And then the worst is there are some companies out there that have very aggressive salespeople, and they use techniques that are called like hotboxing, where they spend a lot of time on the phone with you, and then they say, well, I have to get this sale today, and it's either it won't be available tomorrow, or I'll get fired if I don't sell it to you. And that you never get complete information. You can't find it on their website. You can only get information if you call them, or even worse, you call them and have to give them a credit card number. So do your research before you spend a lot of money with any of these people who are pretending to help you. There are a lot of people out there who are to help you, who are legit, who care, who are in there with you, but there are also people out there just who want to pick your pocket. Contests, and I've made this mistake myself. There are contests, they're $75 a submission, etc. And they say you'll be featured at the Green Book Festival. If you Google Green Book Festival, it doesn't exist. There's no pictures of it. There's no thousands of people. So the fact that you're going to be featured at this festival that may be in someone's garage is not worth the $75. They usually have 27 categories and hundreds of prizes, and the prizes are a sheet of stickers that you can put on your book to say you won this prize. So you need to think about what is the prize, how high are the fees, who are the judges? Are the judges mysterious, professionals, or are they actually naming editors and writers? And then a way to check whether an award has any prestige is Goodreads has a list of awards and they basically organize books by award, so that if you click on award, you can see who won those awards in different years. It's a very long list. It includes lots of different language contests and niche contests. So if you're looking at a contest that's going to charge you $100 a submission, and it's not on the Goodreads list, it probably will give you no prestige to win it. So the last topic is why you want to operate as a business. and this is a new frame of mind for writers. The opportunities for writers have never been better. You can pretty much do all of these different formats yourself, or you could hire people to help you do it. Maybe you can't do theme parks, but you can certainly develop merchandise and games and graphic novels and podcasts, etc. But because it's easier for writers to do this, it's harder to get recognition. But let's talk as a business. The reason why you want to be a business is all of this will take an investment of money as well as time. And again, I'm focusing on the IRS, but the same will be true in the UK and other countries. Our tax structures encourage people to start new businesses and to take these risks. And just because you're working on a book rather than developing software or the cure to cancer or something like that, just because you're doing something creative and you're trying to make some money on it, you're as entitled to take advantage of these tax benefits as anybody else. So what it is, I mean, the biggest tax benefit is that you can take your investment of money that you do early in your career, you know, editing your books, designing them, promoting them. Those early years, you're going to have losses. So it's great if you can deduct those losses, not only from your book income, but from your other income, your day job income. And the only way to do that is to convince the IRS that your writing is not a hobby, but it's a business. And I go into more detail about this in my book, but it's the hobby rules. If it's a hobby, you can still deduct your income from, your expenses from your income. But it's even better if you can deduct your expenses from, if you're a hobby, you can deduct your hobby expenses from your hobby income. But if you're a business, you can deduct your hobby expenses from other income. So in other words, Uncle Sam shares in some of these expenses and you'll have a lower tax bill. In order to do that, you have to demonstrate that you have a realistic plan and motive to turn a profit and make this a business. And it's amazing how much window dressing can get you there. Part of it is doing a business plan that just kind of shows that you have a plan for getting to profitability. You advertise, you join professional organizations, you go to conferences. It's great if you can speak at conferences or speak for local writer groups. Very important, you keep your business and personal finances separate. This can include getting a separate employer identification number for your writing business. It definitely means setting up separate bank accounts once you have income coming in. There's a number of steps, and the important thing is, as you grow, you want to take more of them so that you look more and more like a business, and that you keep writing, that you keep trying to make this work. You also have to follow some of the nitty-gritty tax rules, such as if you're paying anybody more than $600 in any year, any U.S. taxpayer, you have to get a W-9, which gets their Social Security number or their employer ID number, and you have to give them 1099s. Anytime people talk about tax forms, I think our brains kind of fog out and we don't want to deal with it. But these are not complicated forms. They're one-page forms. And then you have to report and pay sales tax on the books you sell yourself, either through your books or at bookstores. Again, these are both very manageable tasks. They're part of the nitty-gritty of running a business. I have covered a lot of issues today about the 5 things that for writers need to know about legal issues. You don't have to keep all this information in your head at one time. There are resources out there, including my blog and my book, and there are other writers who are stepping into this field, other attorneys who are stepping into this field and posting lots of good information to help writers. The important thing to remember is you're not in this alone, that the writing community is really special among business communities, is that even though we are technically all competing with each other, we don't act like that. We act like we're comrades. We're all in this together, trying to change the publishing world and find success both individually and as a group. Well, that's going to wrap it up today. You can, if you have questions, you can contact me through my website, which is at helensedgwick.com. I may not answer the first day you send me, but I usually batch these questions and sit down on a weekend and answer them. So I hope to hear from you, and I wish you great success in your writing ventures.